is a right of the citizenship. If we think about this as privilege, I feel fear. If we think it's a right of all our people, because our boss is our people. Our boss is not the other judge. Our boss is not the parliament. It's not the politician. It's not the people with money, with power. Our boss is in general the people. The boss, your boss, is the Serbian people. My boss is the Canary people, the Spanish people. My idea, my suggestion is, if some person here, or some teacher, or some panelist, has different suggestion, the 14 suggestion of the CCJE, my idea is, please give this suggestion, because all topics today, in general, are around the 14 suggestion of the CCJE in 2014. Excuse me, Madam Chairwoman.
Wouldn't agree more.
Pa ne, ja sam teo povodom ove diskusije da kažem da sam ja malo drugačije shvatio ovo Đurino izlaganje. On zaista rekao to što ste vi rekli, ali sam ga shvatio da je to, Želica pokaže razliku između neformalnog i formalnog. Kada je govorio pa da CCJ predlaže neformalno, pa je u tom kontekstu da mi znamo ko je dobar sudija, ali ipak postoji neki formalni. Dakle, ovo nije bežanje od primene pravila. Pitanje je zaista, kažu u nekim zemljama ne ocenjuju, ne vrednuju rad sudija, što nije tačno. U svakoj zemlji i svuda vrednuju rad sudija. Kao što je rečeno, negde formalno, negde neformalno. Tako su meni rekli, u Danskoj nema vrednovanja sudija. Pa rekao, vi kad birate nekog u viši sud, birate onog boljeg ili lošijeg? Kao je, pa biramo boljeg. Pa otkud znate da je bolji? Pa zato što ste vrednovali, uporedili ste ga. Dakle, vrednovanje se uvek vrši. I ono što je Dragana rekla, svako prilagođava svoji tradiciji, uslovima u kojima radi, pa i zahtevima društvene zajednice, bila ona opravdana ili ne. U situaciji kad imate, kao što je u Srbiji, u principu negativnu sliku u javnosti o pravosuđu, opravdano ili neopravdano, i koliko je pravosuđe samo tome doprinalo, to je drugo pitanje. Ali onda vi gledate da umirite tu javnost, pokušavate da uspostavite neka pravila upravo da biste pokazali, evo dobro, mi radimo po pravilima, a ne po nekom subjektivnom osjećaju. A taj subjektivni osjećaj može nekad biti tačniji od ovoga što se vodi kao objektivno. Dakle, prosto, ja sad da preuzmem ulogu odbrane Đure, pa u tom smislu predlažem da se Đura oslobodi od optužbe. Šalim se, ne, nego ću kaže kako sam ja shvatio tu diskusiju i ja se sa njom slažem u tom smislu, to što kažete, mi svi znamo. I sad je u stvari ključno pitanje, jer većina tako misli, sudija, i što Beba kaže, ali je problem, ajde sad to da pretvorimo u pravilo. Ajde to, što mi svi znamo ko je dobar, ajde da pretvorimo u pravilo. Ne možemo da pretvorimo u pravilo zbog nas, sudija. Mi svi znamo, ali kada bi došlo, recimo, ja ne znam kako je to u drugim zemljama, u Srbiji, kad bi rekli, ajde sudije, vi sad napišite koga vi hoćete da izabere u viši sud. Siguran sam da 80% ne bi napisalo onoga za koga misle, nego bi to krenulo, zapiši broj 8, broj 7, kolega i tako dalje. Dakle, jeste malo problem u nama i podizanje svesti o našoj ulozi i našoj odgovornosti, ne samo prema društvu u kome delimo pravdu, nego i prema nama samima i sistemu u kome funkcionišemo. Dakle, u Srbiji za sada je dobro što postoji formalno, jer je takav trenutak da je potrebno da, ja se nadam da ćemo jednog dana postati Danska i da to neće biti potrebno, ne da ćemo mi kao država u ekonomskom smislu, nego da ćemo mi sudije postati u tolikoj meri svesni svoje uloge i značaja i odgovornosti jednih prema drugima. Za sada je to tako. Hvala.
Sada, da bi se pridržavali koliko toliko satnice, sad ćemo preći na ovaj poslednji panel, posle koga ćemo takođe moći da razgovaramo i prvo ću dati reč domaćem panelisti, zato što će nam on reći u stvari iskustva dosadašnja. Ovde se kod nas formalno vrednovao rad sudija u Srbiji od 2015. formalno. Inače, da kažem, veliko insistiranje Društva sudija je uveden sistem vrednovanja. Znači, mi smo se borili za to da u zakon uđe sistem vrednovanja rada sudija, ali kad je počelo, baš i nije najbolje počelo. O tome će nam prvo pričati panelista, sudija Vrhovnog suda Dragana Mirosavljević, a kasnije ću dati reč Filipeu, jer ja već vidim koliko bi on mnogo stvari rekao, ali će on to sve objediniti kada bude pričao o onome što želi da priča. Dragan, izvoli.
Hvala, Dragana. Poštovane kolege, da se obavestim, ja sam u prethodnom periodu kao sudija Apelacionog suda u Beogradu bila je predsednik Komisije Apelacionog suda u Beogradu za sprovođenje postupka vrednovanja i utvrđivanja ocene rada sudije predsednika Višeg suda u Beogradu. Sada ću vam preneti par zapažanja u radu konkretne komisije i u primjeni pravilnika. Pre svega moram da vam kažem da se radilo o vrednovanju rada sudije Višeg suda u Beogradu. Radi se o sudu čiji je priliv iznad svakog proseka u odnosu na priliv predmeta u drugim sudovima. Prosto to je jedna neverovatna brojka i vi kada treba sada da vrednujete sudije koji ima 2000 predmeta u odnosu na ova merila i kriterijum iz pravilnika, stvarno se nađete u problemu. Tačno je da je postupak vrednovanja u prvoj fazi primjene pravilnika bio zasnovan prioritetno na statističkim podacima o radu sudija i kada biste primenili statističke podatke o radu sudija, tog suda pa većina bi bila nezadovoljava. Međutim, kasnije na osnovu člana 36 pravilnika koji je predviđao razgovor sa sudijom omogućen uvid u potpuniju sliku razloga koji su bili od uticaja na ostvarivanje propisanih merila za kriterijum... Izvinite, molim vas. Znači, kasnije na osnovu člana 36 pravilnika koji je predviđao razgovor sa sudijama, omogućen je uvid u potpuniju sliku razloga koji su bili od uticaja na ostvarivanje propisanih merila za kriterijum kvalitet i kvantitet. Pojedine sudije su davale detaljno izjašnjenje u odnosu na razloge koji su bili od uticaja na ostvarivanje propisanih merila, pa se sećam i sudije koja je lepo izračunala onako obično vreme koliko je potrebno za pripremu i za obavljanje aktivnosti pre suđenja i posle suđenja, pa ispalo da kada bi u stvari ona htela da radi stvarno kako treba, ne znam da li bi imala vremena i da spava u svakom slučaju. Međutim, pojedine sudije su bile dosta pasivne u tom smislu i komisija je, bar ova u kojoj sam ja presedavala, stvarno kroz razgovor sa sudijama pokušavala da ih navede, da nam kažu kakvi su uslovi rada, da prosto ukažu šta je to bilo od uticaja na ostvarivanje propisanih merila. Komisija je upravo ove razgovore i ova saznanja u pogledu razloga koji su bili od uticaja na ostvarivanje propisanih merila koristila prilikom vrednovanja rada sudija, jer stvarno, kao što sam na početku rekla, kada bi gledali samo statističke podatke, sud bi bio u velikom problemu, odnosno sudije bi bilo u velikom problemu i to potpuno neopravdano, jer je pored tih statističkih podataka bilo velike aktivnosti sudija u mnogim oblastima, ne samo u pripremi predmeta, jer nije suđenje da sedete da sudite, već morate i da pročitate predmet, da se upoznate sa nekom praksom, da pogledate materijalno pravo. Ovaj pravilnik predviđa kriterijum kvaliteta i kvantiteta rada sudija. U odnosu na kriterijum kvaliteta rada koji bi trebalo da iskaže sposobnost u primjeni materijalnog i procesnog prava, ovako kako je koncipiran, za komisiju nije bilo nekih problema i nejasnoća, jer faktički taj kvalitet se opet prikazivao kroz neke objektivna merila, to je procenat ukinutih odluka i vreme izrade odluka. Zakonske izmene u pogledu pravila vrednovanja nesumnjivo se odnose i na kriterijum kvaliteta, međutim, treba dobro razmisliti kako, prvo, šta će biti materijal i koji će biti izvor za materijal, što je koleginica već ukazala, da bi komisija ovako kriterijume koji su izraženi u zakonu i koji su po meni na neki način dosta fluidni, mogla objektivno i da prikaže. Što se tiče kvantiteta rada sudija po pravilniku i koji je iskazivao efikasnost u radu i rešavanju predmeta, korišćena je mesečna norma, a to je značilo da se gleda broj predmeta koji su sudije završile u odnosu na broj predmeta koje je trebalo da se završi. Vi znate da je to prvenstveno se odnosilo na meritorne predmete, dok za neke druge predmete, tipa rešeno na drugi način ili u krivičnoj materiji KŽ, KŽ2 i tako, i neki slični, faktički broj 3 predmeta ili 5 predmeta se računao kao jedan. I to su bili na neki način normirani predmeti. Međutim, u okviru ovog odeljka kvantitet bilo je predviđeno da 3 predmeta u postupku u kome se štiti pravo na suđenje u razumnom roku, rešenih po prigovoru i žalbi, da se računaju kao jedan meritorni predmet. Znači, vi uradite 3 predmeta, računa vam se jedan predmet. Pri tome, ova materija nije bila normirana. Nije bila normirana i smatram da u okviru možda kasnih izmena treba obratiti pažnju na način računanja predmeta u okviru prava na suđenje u razumnom roku, da li ove treba predmete normirati, a ako ih treba normirati, onda treba voditi računa i o vremenu izrade odluka, znači izmeniti određene parametre u pogledu vreme izrade odluka, jer se ovde rokovi računaju drugačije, a ako se ne normiraju, onda po meni trebalo bi razmisliti o jednom posebnom iskazivanju kroz određene izveštaje. Takođe važi i za medijaciju, ali evo ja sam se skoncentrisala na predmete suđenja u razumnom roku, s obzirom da su u ovom pravilniku koji smo mi primenjivali bili ovako rešeni. Sad imamo i situaciju nedovoljnog broja priliva predmeta u radu. Kada sudija postupa u jednoj materiji i kada zbog nedovoljnog broja priliva, nedovoljnog broja predmeta u radu ne može da završi mesečnu normu, tada se prema pravilniku ceni ukupan broj rešenih predmeta u odnosu na ukupan broj predmeta u radu. Međutim, imali smo situaciju kada sudija postupa u različitim materijama i, na primer, ukoliko postupa u različitim materijama, vršilo je se sabiranje i kroz to sabiranje dobijala je se neka konačna ocena. Međutim, ostalo je po meni potpuno nerazjašnjeno šta raditi kada u nekoj situaciji sudija postupa u više materija, pa u jednoj materiji ima priliv, a u drugoj materiji nema priliv. Da li ćemo i tada primeniti odredbu pravilnika koja kaže da će se vršiti sabiranje ili ćemo ići na ovu odredbu pravilnika koja predviđa da se u tom slučaju upoređuje broj rešenih predmeta sa ukupnim brojem predmeta u radu. Ono što je upitno u ovom pravilniku su ocene koje se odnose na vrednovanje rada sudija i koje bi nesumnjivo trebale da budu upotpunjene, što vidim da je sada uneto i u Zakon o sudijama. Ja moram da vam kažem u kom problemu je bila komisija. Naime, kada za jedno merilo, znači imali smo kriterijum kvalitet i kriterijum kvantitet. Kod kriterijuma kvaliteta imali su procenat ukinutih odluka i vreme izrade odluka. I svako merilo je bilo podležno ocenjivanju. I sada, vi imate situaciju da za jedno merilo bude ocena izuzetno uspešan, a za drugo merilo bude nezadovoljava. Krajnja ocena po ovom pravilniku je nezadovoljava, ali to nije problem samo za, na primjer, kriterijum kvaliteta, nego i krajnja ocena vodi oceni nezadovoljava. I vi dolazite u situaciju da sudija ne može da opravda vreme, kašnjenju u izradi jedne, na primjer, odluke. Prosto ne može da opravda i vi ste u situaciji da po ovom pravilniku za to merilo njemu date ocenu nezadovoljava, što je stvarno malo neobično ako pogledate da bi rad tog sudije po svim ostalim merilima bio izuzetno uspešan, ali pravilnik je tako predvideo ocene i mislim da u izmenama pravilnika treba, ako uopšte hoćemo da pristupimo vrednovanju, dati jednu široku paletu načina ocenjivanja. Jer ne može se, ako već pristupamo vrednovanju i utvrđivanju rada sudija, to svesti na 2 ili 3 ocene. Mislim da rad sudija zahteva jednu širu tu sliku ocenjivanja, jer bi jedino tako mogli nekako da izađemo iz ovih problema vezanih za statistiku. U čemu je ova komisija takođe imala određenih problema? Pravilnik je predviđao redovno vrednovanje rada sudija u određenim vremenskim rokovima, ali se dešavalo i, mislim, dobijali smo zadatak da vanredno vrednujemo sudiju. Što ne bi bio problem da, na primer, period vanrednog vrednovanja sudija nije bio toliko kratak da vi sada dođete u situaciju da vanredno vrednujete sudiju za 5 meseci. Tih 5 meseci čovjek je mogao da ima zdravstvene probleme, prosto raznorazne probleme i jednostavno to je toliko kratak period da bi moglo da da pravu sliku o radu sudija. Smatram zbog toga da period vanrednog vrednovanja treba takođe posebno obraditi, uzeti u obzir koji je to optimalan period za vanredno vrednovanje, bez obzira što su u pravilniku predviđeni razlozi kada se vrši vanredno vrednovanje. Imali smo problem takođe da sudija postupa, na primjer, u krivičnom odeljenju, gde imate određene parametre prema pravilniku za vrednovanje, a onda u jednom periodu prelazi u neko od posebnih odeljenja. I vi ste sada u situaciji da prosto različita merila morate nekako da svedete na jednu krajnju ocenu. Mi smo gledali, prosto ova komisija je gledala da to na neki način ne bude na štetu sudije i zato nas prozivaju da su svi na kraju izuzetno uspešni. Ali šta smo trebali da uradimo? Da zbog jednog statističkog podatka dovedemo do toga da je 90% sudija nezadovoljava. I mislim da smo u nekom tom procepu ipak pronašli pravo rešenje u okviru ovoga što nam je pravilnik omogućavao, a što definitivno mora da se menja. Pravilnik takođe ne sadrži sve materije i mislim da bi trebalo normirati i niz drugih materija, jer je onda lakše, ako ćemo da vrednujemo, onda da vidimo šta treba da se uradi, koji postotak je sudija uradio, a osim toga, pravilnik sadrži vrednovanje rada sudija posebnog odeljenja za organizovani kriminal i odeljenja za ratne zločine, dok uopšte nije obuhvaćeno posebno odeljenje za suzbijanje kriminala. Znači, ako hoćemo da već vrednujemo rad ovog, ja govorim konkretno o ovom sudu, onda treba obuhvatiti i sva odeljenja, a ne prepuštati komisiji da sada mi vršimo neku analogiju pa da na posebno odeljenje za suzbijanje korupcije primenjujemo pravila i kriterijume vezano za ova druga odeljenja. Osim toga što smo vrednovali rad sudije Višeg suda, mi smo vrednovali i rad predsednika Višeg suda i tu mogu samo da vam kažem da je merilo za vrednovanje rada predsednika suda broj neotklonjivih nepravilnosti u radu sudske uprave, utvrđeno od strane predsednika neposredno Višeg suda. To je nešto što, malo pravo vam kažem, izlazi iz domena našeg znanja, tako da smo mi te statističke izveštaje o pravilnostima, odnosno nepravilnostima rada dosta, da kažem, onako prihvatali, ne bih mogla da kažem analitično, jer smo ih prihvatali zdravo za gotovo. Koje su to sve nepravilnosti? Mislim da bi takođe trebalo detaljnije regulisati. To je, eto, neko kratko izlaganje u vezi muka naše komisije kad smo trebali da vrednujemo sud sa ovako velikim brojem sudija sa ogromnim prilivom po sudiji. Znači, treba voditi računa i možda razmisliti, molim?
I o uslovima.
U uslovima rada sigurno, ali treba i razmisliti da li jedan sud treba baš ovoliko da bude opterećen. Hvala.
Sve što je Dragana rekla je u pravu, to smo i mi rekli. Beograd je kod nas, nažalost, nije došlo kao u Francuskoj ili kao u Nemačkoj do toga da postoje veliki grad, ne samo Pariz ili ne samo Bonn, Berlin, nego da postoje niz gradova u kojima se lepo živi, velikih gradova i mnogo bolje raspoređenosti i broja sudskih predmeta, isto i u Italiji. Kod nas je sve u Beogradu. Srbija ima manje od 8 miliona stanovnika, ako ne računamo Kosovo, a u Beogradu je 2,5 miliona. I onda možete da zamislite koliko je to veliki broj predmeta. Preko 60% svih predmeta u Srbiji se nalazi u Beogradu. A sudija se nalazi kako u kom sudu, kako u kojoj vrsti sudova, 20% do 50%, a jako puno predmeta. Od ukupnog broja sudija, ne znam da li sam sad bila jasna. Što se tiče iskustava i predloga koje bi moglo da se stavi na ovaj sadašnji pravilnik, a koji je ne prošlo vreme, nego pluskvamperfekat sada, s obzirom na to da će morati potpuno novi da se donosi, Društvo sudija je svejedno, pošto je ono izguralo sistem vrednovanja rada sudija u zakone, tu imamo i neke svedoke koji su nam pitali, Fondacije za otvoreno društvo, kad smo pravili 2005. godine projekat o vrednovanju rada sudija koji je iznedrio ovu publikaciju koju smo pomenuli nekoliko puta, oni su rekli kako ćemo da evaluiramo rezultate projekta, pa je onda kolega Čolak rekao, pa dobro, da stavimo da će ući vrednovanje u zakon, sistem vrednovanja u zakon. Mi smo mu rekli, pa kako mi možemo da znamo da će ući u zakon, ne možemo mi da garantujemo, mi smo samo NGO. Međutim, to je posle 3 godine ušlo u zakon. I onda smo mi pasionirano pratili to vrednovanje i recimo poslednji put smo poslali u decembru 2021. godine analizu primjene tog pravilnika na preko 30 strana, gde smo sve ova pitanja, što je Dragana rekla, još mnogo više pokrili i dali jedno 60 nekih preporuka kako bi trebalo da se izmeni, ali je sada to malo outdatovano, što bi se reklo, sada ćemo se baviti sasvim novim pravilnikom. Konačno da vidimo kako u jednoj državi koja je uzorna u tom pogledu, kako vrednovanje rada sudija funkcioniše. Filipe će nam reći ne samo koji su kriterijumi, nego kakav je čitav postupak, a kriterijuma ima dosta u Portugaliji. Filipe Marquez.
So, well, first of all, the usual but not less sincere thanks to the organizers of this conference, which, by what I will be saying after, is for me a very important topic. I had a lot to say in the debate that was going on before, which I didn't, because my presentation would be very descriptive, and I ask for your understanding about it. This topic is a very important topic because it's not only important to ensure quality, but as we all know, and we have been witnessing it in the debate, it's a very dangerous topic for the independence of the judiciary. But what I would like to bring to you, and there was a change in the sessions, I was supposed to speak with Duro Cesa, and I assumed, as he has done, that Duro would be talking about the general principles in international and European standards on the evaluation of judges. So my idea would be to give you a concrete example of how an evaluation system is working in a country, so we can blend the general principles that Duro Cesa would be talking about with a concrete example of how it's going in practice. We are talking about very different realities. I'm going to give you an example of a country where the work of judges is being evaluated for more than 100 years. So we are not talking about if the work of judges should be evaluated. We are talking about how the work of judges is being evaluated. I tried to make some legal archaeology, and the most ancient diploma that talks about the evaluation of judges in Portugal that I found is from 1912. In that diploma, it already stated that the Superior Council had inspectors that would evaluate the work. In that case, at that time, it was not only of judges, it was judges, prosecutors, court clerks, and they would grade it with different classifications of good, very good, good distinction, mediocre, and awful at that time. So I'm not sure if before 1912 there was already a system of evaluation of the work of judges, but at least since 1912 I'm absolutely sure, because I saw the law of 1912 that regulates that evaluation of the work of judges. So I'm talking to you and I will be explaining you, and that's the descriptive part, because as far as I understood from the invitation that was directed to me, the idea was for you to have not a good or a bad example, but a concrete example, so you can draw up your own conclusions if it suits what you are debating right now in Serbia or in the other countries or not. There's no one-size-fits-all solution, so what I'm going to present to you, it's not what I think it's the ideal solution. What I'm going to present to you, it's what is in place. I have some criticisms regarding some of the aspects, but what I can tell you is that this is a system that has been going on for more than 100 years. And during these 100, at least, years, the system has been refined, because during these 100 and at least 11 years, we have faced Republican revolutions, we have faced a 48 years fascist dictatorship, We have witnessed a democracy that has been lasting for 50 years. We have had different compositions of the Superior Council. But nevertheless, despite all these changes, the evaluation of the work of judges has always been a constant. And there are two advantages in my speech today. The first one is that I am a former president of MEDEL, so I will be speaking freely without engaging MEDEL, because these are my personal views. And the second one is that I have two prosecutors and two judges from Portugal in this room. So if they don't agree with something that I say, they are free to contradict me, and that would also be good for you, because from the same country you would have different opinions. So this is my personal view. The descriptive part is objective because it's what the regulations and the law say, but the opinion part, it's my own, obviously. Another thing that I would like to tell you is that what I'm going to tell you is about judges, but it applies also to prosecutors. Until 1979, the careers there was only one career for judges and prosecutors. It was exactly the same career. Everyone would start as a prosecutor, and then some would become judges if they wanted to, and the others would stay as prosecutors. But in 1979, there was a separation of the careers. But that separation was clearly established as a parallel career. So prosecutors and judges have exactly the same salary. They have a superior council of their own. They have an exactly similar system of inspection as judges. There are some slight differences in the regulation. They have their own regulation, but the system of inspections is exactly the same, the body of inspectors and so on. So what I will tell you, and my Portuguese prosecutor colleagues may provide you with some information on the differences that their system has, but what I will tell you applies in general to what the prosecution inspection system is. So, going on to the more specific part, and as I said, I will try to skip just to tell you, I've sent my written speech to Darko, to the Judges Association. I've written it in English and also the PowerPoint presentation, and I said that they can distribute it freely, and if they manage to translate it to Serbian, they are free to do it and they can send it. Also because in the written speech you have web links to the diplomas. Unfortunately only in Portuguese, but if you manage with Google Translator, if you're interested, you have web links to the laws and regulations that I mentioned here. So basically, the Statute of Judicial Magistrates in Portugal clearly says that all first instance judges are subject to regular and periodic inspection. The first after the first year in office, the second after 3 years in office, the third 4 years after that, and after that every 5 years. There was a change recently. When I was inspected after my first year in office, I had a classification just as in any other inspection. In the recent change of the regulation of inspections, it was decided that this first inspection after the first year in office would not end with a classification, because it was an inspection more to help a new judge to improve in some aspects of his work, and as it was only the first year of office, it would not be fair to classify the judges. So it's an inspection not intended to classify the judge, but to see how he or she is working, and to help improve or identify some possible problems that may arise in this first year. That's why there's this difference. So the statute establishes the principles: legality, equality, fairness, reasonableness. It clearly states that there's the principle of independence, meaning that the inspection services may not in any case interfere with the independence of judges, namely by pronouncing on the substantial merits of decisions. So an inspector can never say you decided correctly or incorrectly. The inspector can never say in the report, I think that this case was badly adjudicated. He can say things, for instance, and in all the inspection reports that I've seen, either mine or colleagues that have shown me, the inspectors sometimes say, I'll give you an example. There's some controversial jurisprudential issue which is being debated, I don't know, by Supreme Court decisions. Some Supreme Court decisions decide in one matter and some other decisions decide in another matter. if a judge in a sentence decides a case which is concerning that particular aspect, without assuming that there's only one solution, the inspector can say, he took this decision without justifying why he decided this way, while there are decisions of the Supreme Court that go in another way. So he should have mentioned both, even if he decides this way. At least he should have said, I know that there are different decisions, but I don't agree with them because of this, this, and that. So that's not messing with the decision in itself. It's saying maybe he should have reasoned better his decision. So that's as far as an inspector can go. He cannot say, I think he decided badly, or he decided in this way, but I think the other solution is the more correct one. An inspector can never say that. These are the general principles in the Statute of the Judicial Magistrates, and then the Superior Council has approved the most recent regulation is Regulation 852 of 2021 that you see mentioned there. I will basically focus on 5 points in this presentation. First, the inspectors. Who are they? Who appoints them? How are they appointed? The criteria, the procedure, and then the relevance of the classification, and the final part, which is more a personal one, the advantages and disadvantages of this. I'll try to be quick, I know the time, and I'm sorry because it's very descriptive, this part, but I think it's what you needed in this conference. So, who are the inspectors? Basically, all the inspectors are appointed by the Superior Council of Magistracy in its plenary session and by absolute majority of votes and by secret vote. Whenever there's a vacancy, first, inspectors must be judges of second instance, so of an appeal court, or judges from first instance courts with at least 15 years of seniority and classified with the highest classification in their inspections. Currently, all the inspectors in functions are all second instance judges, so appellate court judges. The regulation says that these inspectors must have recognized qualities for holding the post, namely impartiality, common sense, intellectual skills, technical preparation, human relations skills, motivation, innovation, and result-oriented people. So, in case there are extraordinary inspections of judges of second instance or Supreme Court, the inspectors are appointed by the Superior Council, either a Supreme Court judge, if it's inspecting, it's always a Supreme Court judge, appointed by the Superior Council whenever the judge inspected is a second instance or a Supreme Court one. So basically, whenever there's a vacancy, the Superior Council of Magistracy opens a period of 10 days for application, publishes the announcement in the website. Candidates to the post must present a letter of motivation, their curriculum vitae, and a short text explaining why they think they have the skills needed for the post and how they intend to perform the task. All the candidates are subject to a secret voting in the plenary of the Superior Council, and they are elected by a absolute majority of the votes. The appointment is made for a period of 3 years, renewable once, and in very exceptional circumstances they can be renewed a second time. Every inspector is assisted by a secretary who is chosen from among court clerks with more than 15 years of service and a classification of very good, without any disciplinary sanctions, and with qualities of citizenship impartiality. The secretary is appointed by the Superior Council of Magistracy for a 3-year period, and it's the inspector that suggests one of the names. Basically, the inspector suggests, I would like to have this person as secretary. That person has to present its CV, and the Superior Council assesses if he or she meets all the criteria and approves or not that appointment. Currently, for you to have an idea, there are 16 inspectors and 16 secretaries, each one of them with a determined geographical area of Portugal. So each inspector is responsible for the judges of a determined geographical area of Portugal. In order to better divide the work of inspectors, as you can imagine, Lisbon and Porto have much more judges than the rest of the country. So each inspector has a geographical region of the country and each one of them has, for instance, the first section of the criminal court, and the other one is the second of Lisbon or Porto, so the number of judges to be inspected by each one is well divided. Now for the criteria, which was what we were discussing previously. As you can imagine, during these 100 and something years, this was the most debated point, as we have seen here in this room also. I could tell you, but my Portuguese friends here in the room can tell you otherwise, that all the criticism to the system is never about the fact that the evaluation exists, it's always about the criteria. So I can say with I'm relatively sure that there's almost unanimity that there must be an evaluation system of the work of judges. If you ask a Portuguese judge, I think that nobody will tell you that we should not have an evaluation. It's unanimous, everybody would agree with that. What during the years everybody criticizes is the criteria, which should be the criteria. And this has led to the regulation of the inspections has been changed a lot during all these years, and it has been refined because we have tried to put on in the regulation as more specific criteria as possible. So basically the criteria which are established, the regulation first of all starts by saying that the objective of the inspection is to assess the service actually rendered by judges proposing to the Superior Council of the Judiciary either a positive or negative evaluation following the inspection and a service classification. And paragraph 2 has an important point that says that in pursuit of the aims referred to the previous paragraphs, the inspection must be pedagogical in nature, and this must be an essential aspect of the inspection activity, especially in the first inspection, when it's also important to check the inspected person's suitability for the job. That first inspection that I mentioned you after the first year in office, the regulation clearly says that that first inspection especially must be very pedagogical and not exactly to evaluate if the judge is a very good judge or a poor judge. So it's more to help the judge in this first evaluation. The inspection covers all the work done by the judge during the inspection period in question. The new regulation talks about by sample. The previous regulations would say that it's all the work. For you to have an idea, when I was inspected for the second time, during those 4 years, I had been placed in a special position. We have every year in July, we have the annual movement of judges where you can apply to go to a different city or court. And I was placed in a position which was created 20 years ago mainly because of the increase of number of female judges that were discriminated because when they went in maternity leave, there was no one to replace them. So they would arrive after 5 or 6 months, they would have all the work from the previous 6 months there. So they created a special position of judges who during that year would be run by the Superior Council and they would replace, and I was placed in one of those, so I changed a lot. And this to say, when we say that all the work of the judge is inspected, the inspector that inspected me for the second time told me in the final conversation he had with me that he had been in 21 different courts just to inspect all the work that I had done in 4 years. So he actually went to those 21 courts because I was placed 1 month here, then the judge would come back, then I was placed 3 months in another place, and he actually went to those 21 courts. He saw all the files that I've been. So now it says by sample, and there's a reason to say by sample because with the IT technology, right now they are capable of, at the distance, to see if you have pending cases, if you have delays or not. And at that time, you really had to go to the court to see the actual paper files, which now it's not mandatory to do. So, going to the more important parts. Article 12 of the regulation establishes 3 general criteria: human capacity for the exercise of the function, adaptation to the workload, and technical preparation. But then the same regulation establishes what sub-criteria should be used for each one of these three criteria. For the human capacity for the exercise of the function, you have these sub-criteria established in the regulation. So, sorry, there was something here with the computer. I think I turned off something. I think I must have.
Some cable you disconnect.
I must have disconnected some cable around here or something.
You found it.
Yeah, but oh, this is another one.
Need to turn it.
Recite da li je okay da bude samo po jedan slajd, da nema preview. Is it okay just to show one slide at a time?
Yes, no problem, no problem. Yeah. Okay, so basically, the first criteria, human capacity for the exercise of the functions. It's independence, impartiality, dignity of conduct and suitability, politeness in his or her dealings with procedural actors, other magistrates, lawyers, court clerks, legal professions, and the general public, personal and professional prestige that he or she enjoys as a judge and the resulting of exercising office, serenity, secrecy, and reserve in the performance of duties, ability to understand the specific situations at hand. Slowly, sorry. I know the translation, sorry. The ability to understand the specific situations at hand and a sense of justice given the socio-cultural environment in which the position is held, and the availability and dedication to training of magistrates. The second criteria, the adaptation to work courts, includes assiduity, including, and this is a result of the possibility of people working from home due to IT instruments, including the level of physical presence in court according to the demands of the work assigned, zeal and diligence, productivity, and it specifies regarding the resolution rate, which is obtained by dividing the number of cases completed by the number of cases admitted in the same year, and the recovery rate, which corresponds to the ratio between the number of cases completed and the sum of the cases pending at the beginning of the inspection period, as well as, if applicable, cases pending on the date on which the inspected person subsequently took office in another court or tribunal. This was specified because when statistics started becoming more relevant, there was some disparity. Some inspectors used these rates of resolution and rates of recovery, and others didn't. So it was specified here which resolution and recovery rates should be used, so all inspectors use the same ratios to evaluate. The working method, if it's logical, systematic, and organized, the decision deadlines and the duration of your cases, the capacity to simplify the procedure, the management of hearings and other proceedings, particularly with regard to punctuality, how you schedule your hearings, how you discipline, and how you manage the time in the hearings, and the judge's contribution to the fulfillment of the procedural objectives which are established by agreement between the judge and the president of the court at the beginning of each year. Then you have technical preparation. And the regulation specifies that technical preparation includes the legal level of the work inspected assessed essentially by the ability to synthesize the enunciation of the resolution of issues, the clarity and simplicity of exposition and argumentative discourse, the practical and legal judgment, and the thoughtfulness and knowledge which you show in your decisions. Also, the ability to apprehend the specific legal situations in the case, the ability to convince through the quality and originality of the critical argumentation used in the reasoning of decisions. All these criteria and sub-criteria, according to the regulation, must be assessed during taking into account the circumstances, this is the wording of the regulation, the circumstances in which the duties were carried out, namely the working conditions, the workload, the particular difficulties in carrying out the duties, the level of experience in the judiciary, together with the classification and complexity of the court or tribunal, the accumulation of work, if you are a coordinating judge, if you have other functions in the judge structure, in the court structure, and other legally prescribed or authorized duties. For instance, if you are training young magistrates, the inspector should take into account that you have to dedicate some of your time, not only to the court work, but also to train young magistrates. In the final report, the inspector is obliged to specify his or her conclusions about all these criteria, expressly referring the facts in which he or she supports the conclusions, especially the non-favorable ones. I can give you as concrete examples. Hearings are recorded in audio in order, if you want to appeal, you have the audio recording of the hearings. In my inspections, the inspector, just by chance, decided asked the court clerks, bring me 10 or 20 of the hearings, of the recordings of the hearings, and he heard them. And in the report he said, I've heard 10 or 20 of the hearings he conducted, and I think in this particular hearing he made this, he should have done differently, or he was very polite or unpolite to this lawyer or this. So they hear and they specify and they put in case, 24/2020, in which the hearing was held on the 20th of January of 2021. When hearing this witness, I believe that he had an attitude which I consider not positive. This allows not only to fundament his decision, but as you will see in the procedure, it allowed me also to respond to that, because I know exactly what he is referring to, and I can answer and give some kind of justification for that. So I will try to, although speaking slowly for the translation, to move forward, not to take too much time. These are the classifications with which the inspection ends. It's very good, good with distinction, good, sufficient, or mediocre. Every evaluation of work ends up with a proposal of one of these 5 different classifications. The regulation specifies what each one of these classifications means. Very good, according to Article 13 of the regulation, means that the judge has had a highly remarkable performance throughout his or her career. Good with distinction means that the judge has had a remarkable performance during the inspected period. Good with distinction means good means that the judge has revealed to possess qualities that deserve recognition for the exercise of that function in the conditions that has been carried out during the period to be inspected. Sufficient means that the judge has the indispensable conditions necessary for the performance of the duties, and mediocre means that the judge has had a functional performance less than satisfactory during that period. Only in exceptional cases, everything I'm telling you, it's written on the regulation. So only in exceptional cases, the first classification can be more than good, and the evolution of classifications must be of only 1 degree, except in exceptional cases, which the inspector must specify in his report. So you are not supposed to have more than good in your first inspection, and the evolution of your classifications unless it's an exceptional case, should not jump one of those evaluations that you had. And the classification of very good, according to the regulation, can only be given to judges with 12 years of seniority or more, unless it's an exceptional case, and if the high merit is clearly shown by his or her personal and professional qualities revealed in a particularly complex work performance. The second aspect I would like to point out is that the regulation says that if an inspection detects that there's a significant amount of delays in cases pending due to negligence of the judge, only in exceptional cases there can be an improvement of classification regarding the previous inspection. So these are basically the criteria that are established in that regulation. Now going to the procedure. The planning of the inspections each year is made by the Superior Council, which must publish until the 15th of March the list of all judges to be inspected from the 1st of June this year to the 31st of May of the following year. It publishes that list on the website of the Superior Council, and judges who feel that either they should not be included in that plan or that they were excluded from that plan and that should be there, they have a 10-day period to appeal, and the Superior Council has 20 days to judge on that appeal. So the idea is that every year all the judges know who will be inspected in the following year. This is important not only because you can know that you will be inspected, you will immediately know who will be your inspector, but also you can compare yourself to the other judges who are of the same seniority than you are to know if you will be left behind, because your evaluation, as we will see afterwards, is relevant for your position in the country. So if someone with the same seniority as you has been inspected and you have not, he or she may pass you because they already have a higher classification and you just don't have it because you were not inspected yet. So you can appeal to the Superior Council saying, this is discriminatory because I should also be included in this. When the inspection starts, the judge must be given a 15 to 20 day prior notice of the date of the beginning of the inspection, and the inspection always starts and ends with an interview of the judge inspected. So the inspection starts with an interview of the inspector where he meets you and you are able to tell him or her everything you would like to point out. And there's a final interview where the inspector, after seeing everything, will not only tell you what he has seen, and he will tell you, in principle, the classification he will propose, but you will also be able to hear what he has to say on that. Before the first interview, when you are notified that your inspection will be done, you can send to the inspector up to 10 pieces of work, of written court work that you have done in order to show that you have, well, obviously the pieces that you think are the most well done and that reveal how good you are when you are exercising your function. In the final interview, which in principle must be made in a maximum of 45 days after the beginning of the inspection, the inspector, whenever possible, has to inform the judge on the classification to be proposed. 10 days after the final interview, the judicial inspector issues the written report, which is notified electronically to the inspected judge. The judge has 10 days to reply. You can add any elements or request to the inspector that he does any diligences that you think. And this is the moment where you can reply to what the inspector says. And these are very concrete situations. For instance, he lists all the cases where he found out that you have not written your decision in, for instance, the 10 days that the law provides. And he says, in case number, X, instead of 10 days, he gave the decision after 20 or after 30 or after 25. And you can say it's not true. There was a period, I don't know, of summer which cannot be accounted, or you can say things, oh, it's true that I gave it after 25 days, but if you see I was sick for 10 of those 25 and I gave the proper medical justification, so you cannot count those 25. So these are very practical and bureaucratic things. So you have the opportunity to answer to this report. And then the inspector has an additional 20 days to carry out the diligences that you request or to answer to your answer. And then the final report, your answer, and all the elements are sent to the Superior Council. So the final evaluation is not given by the inspector, it's given by the Superior Council, and we'll get to that. The Superior Council, when receives the classification, is not obliged to follow the inspector's proposal, but in case the Superior Council does not intend to follow the inspector's proposal, it has to notify the judge of that intention. So, and it has happened to me when I received an information from the Superior Council saying, we are thinking of not following the classification which was proposed by the inspector, so we give you 10 days to pronounce yourself if you want to. And I had the opportunity to stress why I think they should follow the proposal of the inspector. So you are always notified by the council if they intend not to follow what the inspector says. Except when the proposed classification is the lowest one, mediocre, in that case it's the plenary of the Superior Council who has to the first, the deliberation in that case is of the plenary. In all other cases, of all the other classifications, the decision on the classification belongs to the inspection and disciplinary affairs section. And this is the composition of that disciplinary and inspection affairs section. It's composed by the President of the Superior Council, which is by inherence the President of the Supreme Court of Justice, which is elected by secret vote among all judges of the Supreme Court. The Vice President of the Superior Council, which is a judge of the Supreme Court, which is elected by secret vote by all judges of all instances. An appeal court judge, which is elected by all judges of all instances by secret vote. 2 first instance judges, who are elected by all judges of all instances by secret vote. 1 of the members of the council that is appointed by the parliament, by the President of the Republic, and 3 members appointed by the Parliament. There's the possibility, if none of these is the rapporteur of the case, then the rapporteur of the case also has a seat, but just for that specific matter. From this decision of the disciplinary and inspection affairs, there's a possibility to appeal to the plenary of the Council. And the plenary of the Council, as you see there, is composed of 17 members. Basically, it's, as I said, the President of the Superior Council in Portugal is the President of the Supreme Court, which is elected secretly by all the judges of the Supreme Court. Then we have 7 judges who are elected by all judges of all instances in secret voting, by lists. So we have different lists. There's a general voting by secret ballot, and it's the hunt method. So there are judges from both lists entering according to the number of votes they receive. You have 1 judge of the Supreme Court, which is the Vice President, 2 second instance judges, and 4 first instance judges. Then you have 7 members who are appointed by the Parliament through a qualified majority of 2/3. And we have 2 members who are appointed by the President of the Republic. So this is the composition of the plenary of the Superior Council in Portugal. And this is the body, the plenary, that has the competence to adjudicate on the appeal from that first inspections council. From this decision of the plenary, there's the possibility of appealing to the Supreme Court of Justice, but only on legality grounds. So you can appeal the decision of your final classification to the Supreme Court, but it's only on legality. So only if there's any procedural flaw or any illegality in the whole process, because the evaluation decision is considered administrative discretion, which cannot be subject to judicial review. So it's a decision of administrative discretion that cannot be controlled. So you cannot ask the Supreme Court to assess if they think you should have good distinction or very good, or instead of good distinction they gave you a good mark, because that is administrative discretion. What you can appeal is that if you think there's been a breach on the contradictory, if they didn't give you the opportunity to pronounce yourself, if the inspector did not follow the rules of procedure, on those grounds you can appeal to the Superior Council.
Violation of the procedure.
So, exactly. So we've talked about the inspectors, the criteria, and the procedure. The 2 final and quick, I promise, remarks. First of all, what's the relevance of this classification? As I said, for your placement in the first instance courts, the first criteria is the classification, and only after that comes seniority. Every year, the Superior Council announces the annual movement of judges. They say we have these vacancies to be filled. All judges have until the 31st of May to present your application if you want to move to a different court. And as the fulfilling of those vacancies may give rise to another vacancy, basically, everybody can move. Every year we have this movement of magistrates, and you know, because it's published on the website of the Superior Council, the seniority list, so you know in which position in terms of seniority you are. And when the Council publishes the final decision on who goes to which court, it has the classification of that judge, so you can know if it was according to the rules. Because if we have the same seniority, if Dragana is classified with very good and I'm classified with good distinction, she will be before me in the application for a movement. Even if I have much more seniority than her, if she has a higher classification than me, she has preference over me. So the first criteria is the classification, and only after that seniority. So you can imagine why it's important that judges with the same seniority or different seniorities are at least classified. For specialized courts, family and minor, labor, civil cases more than 50,000 euros, criminal cases of more serious crimes, which have a higher remuneration, the statute of judicial magistrates say that those positions can only be filled by judges with more than 10 years of seniority and with a classification of good with distinction or very good. So if you don't have at least good with distinction in your evaluation, you cannot apply for those specialized courts. So that's also a relevant consequence of the classification. And finally, to access appeal courts and the Supreme Court,